Okay. Wes brought up this topic, and it's one I do like talking about. And your first topic you kind of mentioned that's top of mind was independent administration. Did I pronounce it right?
Correct.
Versus court supervised administration from that standpoint. Explain the difference for the listeners.
Yeah. So just to kind of give you context of what we're speaking about here, this has to do with successions. And, our firm does a ton of succession work. So we're helping the heirs, the executors, get that property transferred over to whoever is named in the will or whoever's going to inherit by law if there is no will. And so in certain circumstances, you have a succession in the state that requires some work, right? Some estates are very straightforward. You might be leaving everything to your spouse. And when we say everything, we mean everything. There is a will there. The spouse is clearly identified as the executor, clearly identified as the only heir. And we can go in and get from point A to point B pretty quickly, right? We don't need any administration in that estate. We can prepare all the documents, get it into the court for the judge to review, and ideally have that succession wrapped up in a short period of time. What we're talking about here is a bit more of a complex estate, one that's going to require assets to be sold or managed, debts to be paid down or managed. Maybe there's a business that needs to be run and managed up to a certain point so that it can be sold or valued, so that there's a transition period between the heirs. There's a variety of different reasons why a different succession might need administration, but the point here for our discussion is that this is not an open and closed situation. This is a situation where you do have a succession that's open for probably a year or more. Right. Sometimes it's 6 to 8 months, but we're talking where, this situation, we know we're kind of in it for the long haul. Right. And so what we want to do is put our best foot forward at the very beginning. And that's the topic, right? That's what the difference is between independent administration and court supervised administration. It is telling the executor what kind of authority, what kind of restrictions and boundaries they have on the actions that they need to take to administer the estate, right? To sell, to pay down, to manage. And there's a massive difference between an executor who's working within what the law provides for as an independent administrator of the estate versus a court supervised administrator of the estate. The way you get from independent administration to court supervised administration or vice versa happens in one of two ways. Number one, the easiest way is to put it in your will, right? All of our wills, after a discussion with the client, typically include this provision, right? We want to understand, even if we don't anticipate the estate being one that's requiring administration, we want to plan for it anyway. Odd things happen, and look, we want to know if we have to flip the switch and do a full administration of the estate, we want to be operating under independent administration to the extent possible. The other way that you can do it is all of the heirs can agree that the executor that's appointed can be an independent administrator. Sometimes that happens. Sometimes it doesn't. And that's where things can get muddy, right? That can lead to litigation. You might have someone who agrees to an independent administration and then kind of sees the way that the executor is performing and decides, man, I really have some buyer's remorse here. I'd like to undo that. And so maybe there's a motion filed to unwind that. Maybe there's a motion filed to remove the executor altogether. Those kinds of things happen. But the essence of it is you really typically prefer the independent administration. And so the easiest way to do that is to have a will and provide for it directly in the will, right? What does it look like, the difference between an independent administrator and a court-supervised administrator? That's really the heart of the conversation. That's the heart of the topic. And I think it's super important because when folks come to my office and we're talking about successions, their biggest concern typically is time. A lot of my clients have gone through the succession process with their parents already. And they say, Wes, that was a nightmare. It took way too long. It cost way too much money, and it was very frustrating. And I felt like, we were 2 steps forward, 1 step back the whole way until we finally got across the finish line. I can understand that. And if you want to know what that feels like, go with the court supervised administration, because you're going to be filing one thing after another, asking for every debt to be paid down, asking if you can sell an asset, asking if you can make certain decisions. Maybe you need to pay an attorney, right? Maybe you need to hire a professional. You need to file an accounting every year. These are things that not only take time, but cost the estate money, right? Each time that you're filing this and you're asking for a judge's approval on this, look, this can be anywhere from 14 days to 45 days before you get that approval. Certain requests may be done ex parte, meaning you don't have to go in there and argue about it. Other requests might require a hearing where necessarily you're 30 to 45, sometimes 60 days out if there's a conflict with the dates. These are things that, again, take you from a quick turnaround time to something that lasts a year or more. And again, just looking at my experience with the clients, that is their biggest gripe, is how long this takes for something that we all think is somewhat simple. So we kind of want to highlight that, because if you're planning, you certainly want to make sure that the biggest step that you make is a smooth step forward for your heirs, right? We want to make sure that that's the easy transition. That's what everyone's going for. So for those folks who choose to do it with a will and go through the succession process, we want to make it smooth. But it's also, frankly, why some people come in and say, look, I want to avoid that process altogether. I understand that there's some pros and cons to a revocable trust. Tell me more about that. If one of the biggest pluses is that I can avoid a succession, let's talk about whether that's worth my time and money, right, to avoid that, because I've done it twice with my parents, and I didn't like it either time.
I could see where, say, 6 different things come up along the path within that. When you kind of mention 45 days on dealing with something and running it through the court, and that would probably be getting it done quick. But if you have 6 different things come up, you're at a year right there, and that doesn't mean you have it solved.